This is case number 20-156709. This is an add-on to the court schedule. This is Community Choice Credit Union versus the Van Garrison. Record should reflect matters before the court on plaintiff's motion for entry of judgment. The record should reflect further that this matter was previously settled with a stipulated order of conditional dismissal. The motion submitted to the court indicates that there has been a failure of the issues of the dismissal, and plaintiff prays for reinstatement and entry of the judgment at this time. For Community Choice Credit Union, do I have someone here on that matter? Do I have Mr. Van Garrison? Right, and this matter was set by way of a notice of hearing for 9 o'clock this AM. I will come back to it briefly. The court now calls case number 21-166312. This is Dearborn Payne Specialist, PLLC versus City of Detroit. The matter is before the court on the defendant's motion for summary disposition. Your appearance for the plaintiff at this time, please.
The plaintiff has indicated.
Your appearance for the City of Detroit, please.
Cheryl Ronk on behalf of City of Detroit, 54897.
Ms. Ronk, I'm not able to hear you much. Maybe try and turn your volume up a little bit.
Okay, I'll try to talk a little louder. I think I got my volume all the way up. The plaintiff's attorney contacted me and indicated that they are not going to defend the motion for summary disposition and requested that I send them a proposed order granting the summary disposition. I did. Plaintiff's attorney agreed to sign it, and we're ready to submit the order granting summary disposition.
All right. So I will sign the order upon presentment. If you could email that to my clerk, I'm going to give you her information. That's Latifah, LATIFAH dot Hunter
Okay.
at 36districtcourt.org. That's Latifah, LATIFAH.
Okay, I will do that, Your Honor.
All right, we'll get that right back to you, Counsel. Thank you. Good day to you.
Thank you.
All right, this is case number 03137346. This is CFC Financial LLC versus Ashura Chapman. The matter is before the court on a motion to set aside a default judgment. Counsel, your appearance, or do I have the appearance with CFC Financial?
Yes, sir. William Hill, P. 28608, appearing on behalf of plaintiff.
All right, thank you, Counsel. I'm looking now for Miss or Mr. Chapman living on Copley Street in the City of Detroit. I do see that this is set at 9:45. That's the time slot I have. So I'll come back to that matter.
Okay.
Thank you, Counsel. Counsel, are you here on any other matter, Mr. Hill?
No, sir. That's the only one I've got.
Thank you, sir. See this? Change. All right, this is a recall on 03137-346 CFF, strike that CFC Financial LLC versus Ashura Chapman. Matters before the court on filing a motion to set aside a default judgment. The record should reflect that the judgment was entered by default in this matter. That was on the 8th of March of 2004 for $3,055.40. Defense. Your appearance for the plaintiff in this matter.
Morning, Your Honor. William Hill, P 28608, appearing on behalf of the plaintiff.
All right, thank you, counsel. I'm looking for Shura Chapman. Anybody representing Ms. Chapman, say something at this time. All right. Looking at the motion, it seems that that there is a handwritten document attached to the motion, wherein the defendant states that she didn't know anything about the complaint, had no idea of this case. In order to have appeared, she indicates the passing of her brother, caring for her mother, and that the case could have been taken care of a long time ago. Counsel.
Your the defendant hasn't really put forth a meritorious defense or good cause. I noticed in the file, this was a default judgment entered in 2004. It was renewed 10 years later. From time to time over the years, there have been multiple tax garnishments issued. I printed out the register of action on the case. There hasn't been any action to set aside this default judgment at any time until 2021. I think it's late. I don't think there's a meritorious defense that asks that it be denied.
And I reviewed the same history, and I would have to say that your assessment of this based upon the register of action is in fact correct. That even though there were multiple opportunities for a defendant to say something regarding this matter over the years, it wasn't until recently that there was anything said. It appears also that the defendant is not present at this hearing, although proper notice was given in this regard. I will deny the motion to set aside judgment where the court finds that the defendant has not established either good cause or a meritorious defense to support her claim that the default should be set aside. And I'm signing the order consistent with the same.
Do you need us to prepare an order, Your Honor?
I can use the form order here.
Okay.
So I'll sign that up and we'll get that out. We'll get a copy of that out to you. Thank you, counsel.
Thank you, Your Honor.
Mr. Wilson, I take it that you are here on various default matters. Is that correct, sir?
Yes, Judge, I have just one today, though.
All right, thank you. I'll be right with you on that matter. Do I have anyone here on Community Choice versus Devan Garrison? That's Mr. Holzman's office. Again, the court called this matter 2156-706. Notice was given in the On the motion for entry of judgment in this matter, the plaintiff indicates that the stipulated order of dismissal, conditional dismissal, should be set aside and set forth reasons in the motion for the same. Primarily that there has been a failure to pay under the terms of the conditional dismissal. The court indicated in the stipulated order for dismissal that the dismissal would be set aside upon the present of an affidavit showing that the matter has not been resolved, or that it's not complied. Mr. DeLuca, are you on the community choice matter? And Mr. DeLuca, good morning to you, sir. You able to hear me? You're on mute, sir. Unmute yourself. I'm dealing with community choice credit union. Can you hear me, Mr. DeLuca? All right, Mr. Bloomberg, you hear me okay, correct?
I hear you fine, Your Honor. Yes, thank you.
Mr. DeLuca? Maybe on this matter, so we'll have to come back to it. All right, so Mr. Bloomberg, let's find out what case you're on, sir.
It's 21 166312 Dearborn Pain Specialist. I have agreed to there was this MSD. I've agreed to entry of an order this morning with Ms. Ronk, and I just wanted to appear and let the court know.
All right, and I have that order in front of me, Ms. Ronk. Ms. Ronk did appear, and she informed me of the same. I'm signing the order at this time, sir.
Thank you, Your Honor. Have a good day.
Likewise to you, sir.
Thank
you. Mr. Wilson, give me the last four digits on the one that you're on, sir.
The last four digits are 2914, Judge.
Got you, sir. This is case number 21162914. This is Credit Acceptance Corporation versus Leonard Henderson Jr. The matter is before the court on the application for entry of default judgment. The default in this matter has already been entered. The defendant did not respond to the complaint and has not otherwise pled in this matter. The court set this matter on for hearing as to whether the defendant can show cause of why the judgment should not enter as applied for. Your appearance, counsel.
Judge, may I please court Richard Gruesome? My bar number for the record is 35222. I'm the attorney of record. I'm also the petitioner today for the plaintiff.
Thank you, counsel, and good morning to you, Mr. Rosen. I'm looking now for Leonard Henderson, living on Wildermere. If you're on this Zoom, please say something at this time. If I have Mr. Henderson on this Zoom, please say something at this time. All right, it appears now that the defendant has not appeared regarding this hearing, although it was duly set. The court did take care to have notice sent to Mr. Henderson on Wildermere in the city of Detroit. The matter was set on for 9:45 a.m. It is past that time. The court accordingly will enter the judgment at this time, the default judgment on the request of counsel. The court has received an order, proposed order, indicating that the amount is $13,613.23. The judgment will be entered as prayed this time.
Thank you, Judge.
Thank you, counsel. We'll get that out to you, sir.
All right.
Mr. DeLuca, Council? Are you able to hear me, sir? Good morning to you, Mr. Steve DeLuca. Community Choice Credit Union. Just one moment. This is case number 21-161-613. This is Preston Morgan versus Aisha Morgan. The matter is before the court on the filing, settlement for pretrial and filing of a complaint in this matter. An answer has been provided to the same. All right, plaintiff, your appearance for the record and or your counsel at this time. Preston Morgan. Well, I see your name there. Anybody representing Mr. Morgan? Mr. Morgan, if you'll unmute yourself and say something, sir.
Yes, I'm
All
sorry.
right,
Good morning.
We were last here. You indicated that you wanted to retain an attorney. Did you do so, sir? Mr. Morgan, did you retain?
No, I was unable to, Your Honor.
All right, very well. Your appearance for.
No, I'm going to withdraw.
I'm sorry, hold on. Let me get the other side in. Your appearance for the defendant in this matter, please.
Yes, good morning, Your Honor. Darren Canfer on behalf of the defendant, Aisha Morgan.
All right, your P number, if you will, for the record, counsel.
Yes, it's P44773.
All right, thank you. Thank you, Mr. Camper. Good morning to you. Mr. Morgan,
Good morning.
you were saying, sir, about withdrawing something. What were you talking about, Mr. Morgan?
Yes, I was going to withdraw the case, Your Honor.
Is that what you wish to do?
Yeah, I'm unable to afford the legal services, and I tried to reach legal aid, but I was unable to successfully get someone. So I'm just gonna withdraw it at this time.
All right, so you don't believe that you could advance it without the assistance of someone else, or it's just generally your desire to dismiss the case at this time? That pretty much what you want to do?
Yes, Your Honor.
Mr. Camper?
I'm not going to object, Your Honor.
All right, on the application of the plaintiff in this matter, the case will be dismissed. That dismissal is without prejudice at this time. But the case is dismissed. I'll sign an order and get it out to both sides regarding this matter. All right, I wish you well. Good day to you.
Thank you.
Thank you, Your Honor.
All right, the court is calling case number 21-159-304. This is Michigan First Credit Union versus Tanisha Robinson. As before the court set on for a hearing regarding entry of a default judgment. The record should reflect that a default has previously been entered in this matter. Today is the date time set for a hearing relative to the entry of the default judgment itself. Your appearance at this time, sir.
Good morning, Your Honor. Stephen DeLuca on behalf of the plaintiff, Michigan First Credit Union. My T number is P70009.
All right, thank you, Mr. DeLuca. Do I have Tanisha Robinson on this Zoom? Ms. Robinson, you're on this Zoom, please say something. A person reportedly living on Kentucky Street in the city of Detroit. All right, it appears that the defendant has not appeared on this matter. It is set for 9:50. It is now 10:05. The defendant did not otherwise respond to the complaint or otherwise defend any underlying action. And counsel, I believe that you're moving for the entry of the judgment itself. Is that correct, sir?
That's correct, Your Honor.
All right, I do not have a copy of a proposed judgment in the file. I will enter the judgment based upon the terms set forth in the complaint in this matter. You were alleging damages therein in the amount of $7,147.32. I'll sign a judgment consistent therewith together with costs and statutory fees. You want to present that by way of email, sir?
Sure, we can do that. And just so the record's clear, we would be requesting a judgment in the amount of $7,147.32 in damages, $187.17 in court costs, and a $75 statutory attorney fee for a total judgment amount of $7,409.49 plus statutory interest. And I can email a proposed judgment to you, Your Honor.
All right. Do you have an email address to you, counsel? Latifah, LATIFAH.Hunter. That's at 36districtcourt.org.
All right, will do. Thank you.
All right, and I got a couple other cases with you, so just hold tight for a second.
Sure.
So I have case number 21-155-404. That's Advantage One Credit Union versus Carmela Orr. And that's before the court on a motion for entry of default judgment. The record should reflect that the default was previously entered, and the court set it on to hearing on today's day as to whether or not the judgment should be entered. The proposed judgment amount on default is $12,767.45. Do I have? I know that Mr. DeLuca, you've been your appearance previously, sir. Do I have Carmelita Orr on the Zoom? Carmelita Orr, living on Ferdinand Street in the city of Detroit. If you're on the Zoom, please say something at this time. This matter was set on for 10 o'clock a.m. It is now 10:07. I do not hear or see a response from Ms. Orr. Again, Ms. Carmelita Orr. Given that defendant has not appeared in this matter, counsel, I suppose that you're asking the court enter the judgment as presented. Is that correct, sir?
Yes, please, Your Honor.
All right, the court will sign the order then at this time, based upon the fact that the defendant has not responded to the complaint nor to the court's call. Judgment is entered by default at this time.
Thank you.
And then there's one other, Mr. Neville. This is case number 21-56709. And this is Community Choice Credit Union versus the Van Garrison. This matter is before the court regarding an application for entry of a judgment of claim and delivery. In that motion, there's a motion filed for entry of a judgment. There's a stipulated order for conditional dismissal that was signed in August 11th, strike August 17th of 2021. The motion for entry of judgment indicates that the stipulation and for dismissal, the terms thereof have not been satisfied, and that the plaintiff wishes that the court will set aside the dismissal and enter the order for claim and delivery regarding this matter. Your appearance on that.
Yes, good morning, Your Honor. Stephen DeLuca on behalf of the plaintiff. My P number is P70009.
All right, thank you, sir. You set this matter on today's date by way of the notice of hearing. It was not originally on my docket, but your notice of hearing established this date, and your notice of hearing, together with your proof of service, indicate that Mr. or Mrs. Van Garrison was notified at their address on Warmer Street in the city of Detroit. So you're asking to enter the claim and delivery judgment. Is that correct, sir?
That's right.
The challenge here is that your motion seems to be on all fours regarding this, but a part of this is that the motion indicates to me that there was to be an affidavit of non-compliance regarding this matter for the setting aside. I don't see an affidavit of non-compliance.
Oh, let me see what I have here. My records show that back in December, we filed an affidavit of non-compliance, but without a motion, just an affidavit of non-compliance and a proposed order. And
Maybe
I don't know if that's in your records, but that's what we first did. And we didn't get the judgment, and so we decided to file a motion to get the judgment entered. We should have attached the affidavit to the motion just to be safe, but apparently we didn't do that. But I show that we previously did file the affidavit.
I see where there was a previous judgment proposal filed. Ah, there it is, hidden among all of this stuff. I found it. All right, I was looking for it with the motion. But yeah, it is in the file now. Let me just take a look at this with this one on.
Sure.
The record reflect that I do have a affidavit of non-compliance attached to some other document that was filed previously before on November 22nd, 2021. And then subsequent to that time, motion filed with today's date is here. Given that there is an affidavit of non-compliance, the court will grant your motion in this matter, particularly where I have not seen Mr. Van Garrison. If you're on the Zoom anywhere, please say something. It's not Van Garrison living on Warmer Street. All right, where the defendant has not appeared and where there is an affidavit establishing non-compliance with the conditional dismissal. Conditional dismissal will be set aside at this time. The court will enter judgment at this time for claim and delivery as requested and per the terms of the consent order of dismissal. So you have that order served and signed. There this time.
Thank you, Your Honor.
Thank
I'm sorry, I didn't catch the last part. You do have the proposed order, correct?
you. Yes, I do.
All right, thank you.
Hi, Mr. Goldstein, and thank you, Mr. DeLuca. Good day to you, sir. Mr. Goldstein, which case, which matter are you on, sir?
Good morning, Your Honor. I'm here on the matter of Smart Start Michigan versus Brian Tanks, docket 21-162-708.
Thank you, counsel. This is case number 21-162-708. This is Smart Start Michigan versus Brian Tanks. The matter is before the court on an application for entry of default judgment. The record should reflect in this matter that a default was previously entered where the defendant did not answer or respond to the complaint or otherwise defend in this matter. The court set the matter on for hearing on today's date for defendant to show cause as to why the judgment should not enter, given that there has been no defense raised in this matter. Your appearance for the record, counsel.
Yes, Your Honor. Thank you. Steve Goldstein appearing on behalf of Smart Start Michigan.
Your P number, if you will, for the record, sir.
Yes, thank you. P47995.
All right, thank you, counsel. Good morning to you. Do I have Mr. Brian Tanks on the Zoom? Brian Tanks is what I'm looking for at this time. If you are Brian Tanks and you're on the Zoom, please say something at this time. The matter is set on for 10:10. It is now 10:14. The court is looking for Mr. Brian Tanks on South Martindale Street. The record should reflect that the notice for this hearing was sent out, and I have that noted in the court's file with the proper Zoom address. It appears that the defendant has not responded to the court's call regarding this case. Your pleasure at this time, Mr. Goldstein.
Yes, Your Honor. We would request entry of a default judgment, which we have submitted a prior default request and judgment for the amount requested in the default.
I do have your proposed judgment in this matter. The court will enter the judgment by default in the terms as prayed. The total judgment amount will be $2,905.35. The order is entered at this time. Thank you, counsel. Good day to you, sir.
Thank you, Judge. Have a good day.
The court now calls case number 21-158-114. This is Jefferson Capital Systems LLC versus Robin Reeves. The matter is before the court on the application for entry of judgment by default. The record should reflect that the default is already entered in this matter, and that is based on the fact that the defendant did not respond or otherwise plead regarding this matter. The court set this hearing to determine whether the defendant can show good cause as to why the judgment should not enter. Your appearance for the plaintiff regarding this matter.
Morning, Your Honor. Sean Bodwine, P71644 on behalf of the plaintiff.
All right, thank you, counsel. Good morning to you, sir. Do I have Robin Reeves? Robin Reeves is who I'm looking for at this time. Living on Braille Street in Detroit, Robin Reeves. It is now 10:16. This matter was properly set on for 10:05. The court has a notice within the file indicating that the proper Zoom address was advanced to defendant Reeves. The defendant does not appear to have appeared for this hearing. Accordingly, now on the application of the plaintiff, the court will enter now the judgment by default, finding that there is due to the plaintiff the total sum $2,796.76. The judgment will be entered as prayed at this time. Thank you, counsel.
Thank you, Your Honor.
The court now calls case number 21-158359. This is Jefferson Capital System LLC versus Diamond Fulham. The matter is before the court on an application for entry of default judgment. The record should reflect that the default has been previously entered. Defendant did not respond to the complaint, nor has defendant otherwise defended in this matter. Counsel, your appearance once again regarding this case.
Good morning, Your Honor. Sean Bodwine, P71644 on behalf of the plaintiff.
Thank you, counsel. And I'm looking now for Diamond Fulham. Diamond Fulham living on Grasset in the city of Detroit. Diamond Fulham. This matter is set on for 10:15. It is past that time at this time. Property was sent out to the address given in the file for the defendant. Defendant has not responded, has not appeared. On that basis, the court will now enter the judgment by default on the terms as prayed, finding that there is due to the plaintiff the total sum $3,290.21. The judgment is so entered by default at this time.
Thank you, Your Honor. Thank you. We all set?
Yeah, that's it that I have for you, sir.
Thank you. Have a good day.
Likewise. On the rivalry phone there, who are you, sir?
I think you got an ear to it, like you're trying to listen.
Is that his ear?
Yeah, this is here. There you go.
Oh, there you are, yeah.
Good morning. Tell me what case you're here on. You have to hit *6 to take yourself off of mute. Tell me which case you're here for.
There you go. Let's put it back to his ear.
You have to hit *6 to come off of your mute. Turn it up. Good morning. Morning.
He's on mute now, Judge.
Yeah, but you should be able to hear me.
Oh, this is true.
If you're able to hear me, hit *6 to take your phone off of mute. Good morning.
Come on.
Good morning to you. What case are you here on?
21-423.
One moment. Don't have it. Did you check it on there?
What is case number?
Give me your case number again.
212-423.
CB David.
His court date is 3/20. I'm sorry, his court date small here. Oh, he probably had something that was downstairs. They transferred it over here. Let's see what he did. Okay, the last time he had a court date, he said his last court date was in November. It says motion side default. Says how the default was denied. Motion to reinstate is denied, and that was it. And then it says parties present, so I'll give you a copy of this. That was the last thing that happened. I was back in November.
Yeah, you don't have a hearing today. Today, the motion to set aside default, I believe this was denied in November. That's the last action on this case.
Yeah, and I brought the new case in that my witness that did, I did buy a new motor for the car, you know what I'm saying? And I brought that in, so they gave me the remotion because they said that I didn't put my zoom in right when I was putting my zoom in. So they gave me the remotion of the new a default where I did get the paperwork and all that to down there in time enough.
Well, you don't have a hearing in front of me today. The last thing that happened in your case is the motion to set aside the dismissal was denied. That was done in November.
Right, and you told me that I got to step up to another judge because you denied it because you had another judge coming in front of me.
This is associated with that's afterwards. That's afterwards.
I want to know why I have to been denied.
And they was stepping up to another judge and you was gonna deny it and I had said I had to get another judge or something about another attorney judge or something.
All right. So it looks like what you did is look like you filed a new case in November.
Right, because I had got paperwork to show you that I did buy a new motor for the car and everything, and I wouldn't leave my witness to know unknown that I brought it down there and showed them that I did have bought the paperwork, bought a new motor for the car to go in. At Highways Motor Park, I brought all that down there.
Yeah, none of that is in front of me. You filed a new case. What you have to do with a new case that you filed, you have to serve GB Auto Sales over with the new case that you filed.
Yeah, I did that too.
Well, I don't have any documentation that has occurred. And once you do that, then what will happen is that you'll get a court date on this. But you haven't filed anything with the court showing that you had been served on the new case. The last case came to an end with the motion being denied. Now you have the right. It's been a little while now, but you had the right to file something for a rehearing on that case, but nothing has been filed. But then what you did do is you filed a new case. That's 21-170-336. That's your new case. And in order for you to advance your new case, you have to make sure that you serve GB Auto Sales with the proper paperwork, and then you have to file your proof of service with the court, or have a bailiff to serve it, or somebody serve it, and then a court date will be set.
Okay, can you write that case number down again for her? Here you go. Okay, what is it? What is it?
Your new case is 21-170.
21170 what?
336.
336.
Yes.
So what I got to do now? Take them back all that where I bought the motor and all that.
Here's what you did. You've done a couple of things. The first time that you filed your case, you did it the right way. You filed it and you had somebody to serve the plaintiff, and then you got a court date, and whatever happened there is what happened in that case. Then you filed a new case, and the new case was filed in November. So when you file that new case, you have to make sure that the other side gets served with the documents in that new case. Now, you have to make sure you get served with the documents in the new case. The other thing that you could do is even in the old case, you could file something called a motion for rehearing. And you'd have to file the paperwork, motion for rehearing, and then try to get that back in front of the court. But right now, you don't have anything pending before the court because that other case is dismissed. You could try to get it reinstated. That's your 21-24 case. You could try to get it reinstated by filing a motion, documents asking the court for a rehearing and try to change that. Or you can go forward with the new case. The new case is the 21-17 case. And in that case, you would have to have a bailiff or somebody to serve the complaint on GB Automotors. And then they would give the document to the court and then the case would get be assigned to court.
Okay, so you telling me to go and put it in there for a rehearing, right?
Yeah, I'm telling you, you have a choice to do that. That's probably your most direct way to do it, is to file a motion for a rehearing on the motion to set aside the motion to set aside dismissal. You might want to file something asking for a rehearing and then tell the reasons why you believe that it should not be dismissed.
So I got to go downtown and do a rehearing motion.
Yeah, you could do it. I believe you can do it online. At 36districtcourt.org. I believe that there's a way that you can file that online and get the process. And again, if you file that motion, you will do that under 21240023.
212004.
Oh, the case number you came here with. You would do it under the old case. Case number that you came here with.
The same number I've been using, I could use that number.
That's the number that you would file for reinstatement if you were trying to get reinstated.
For the rehearing.
Yep.
Yeah. Okay. So I guess I got to go work with this then. I don't know how this gets. See, I got messed up because they gave me the wrong PIN number. I mean the Zoom number, and I didn't zoom it in right. And it's been messed up ever since.
All right. Well, you go ahead and file your paperwork and make sure you put on there reasons why you believe the case should not be dismissed. Put on there also that you were having problems getting in on Zoom, and that's what
Right.
resulted in the case being
Right.
dismissed. So that all of that can be reviewed.
Right. That's what I had a problem with getting on, because I would have been on there, but I just made the last three. Okay, so I got to go to paperwork on this for a rehearing.
Yes.
All right.
All right. I wish you well, sir. Good day to you.
Okay. All right. Good day, Donald. Bitch. Where's the pen at for this shit? This shit is all wrong.
We gotta go and make copies of that
This
first.
shit is all wrong. All this shit here is wrong.
What?
Okay. Yo, people. I would say I hope he'll say nothing. I hope he or she, whatever that was, don't say anything out of line. Okay. Yeah, so. It's kind of cute.
Well, we just already for the city of Detroit.
What you say, Jeff?
Yeah, it's 10:30. The city of Detroit. Goes back. RX. Versus city of Detroit.
Grospect. Yeah, what case was that?
That's the only one at 10:30.
819.
Second page.
Oh, okay, I see it. Yeah.
Man, trying to get a business paper.
That's what you say, good and cool. Mm.
I got my COVID test in the mail yesterday. Did y'all get yours? You know, the public thing that the president wanted everybody.
Oh, you know the free copies? The free
Yeah,
test?
yeah.
No, I haven't got mine yet.
I was
What
like,
they
what?
look like?
I didn't even open it. Where is it?
Little boxes and stuff, they give you like, get up to 4, I think, 4.
It's 4, yeah. 4 in the box. I don't even, let me see where did I put it. Because wait a minute. I'll show it to you. We like to party.
Here she go.
Oh, B.
Yeah.
Can you see it?
Yeah.
There's supposed to be 4 of them in here.
Okay.
You say you like this job.
I don't even know if I should open it because I don't have it. So I'll just leave it here.
No, you don't have.
I know I don't have it. I know. God already told me. Well, I'll be down there Friday. Y'all won't be there though, huh? Doing exams with King.
We'll be here on Friday.
That's right. Oh, Lord. Why are we still on Zoom? Okay.
No, we won't be here. Oh, yeah, we'll be here. Just, I thought you meant like cases.
Right.
I was like, yeah, cases.
Ain't no off days.
You're not in our courtroom, especially.
We'll go ahead and call this one. I don't know where they are.
Okay.
Case number 21. 160-819. This is Grospect RX LLC versus City of Detroit. The matter is before the court set for a pretrial conference. The court did set a scheduling order in this matter. That scheduling order set this case up for return on the 6th of January. It looks like we adjourned from that date to 8. And so I don't know where the parties are this morning. I know that both sides in this matter have been diligent. And so what I'm going to do, I will go ahead and set it for a new date, and then the clerk will send out a new notice regarding this matter.
We like to party.